7 justices of the United States Supreme Court issued an emergency ruling in the dead of night. And by the time most of you poured your first cup of coffee the next morning, you had absolutely no idea it happened. 7 of the 9 most powerful judges in the most powerful court in the land, a 7-2 supermajority that crossed ideological lines in ways that should have stopped every major news outlet in America cold-handed down what legal scholars are already calling one of the most consequential structural rulings in a generation. And it didn't lead the news. It didn't trend on social media. It got buried, swallowed whole by the celebrity gossip cycle, the partisan theater, and the daily factory-produced outrage that is specifically designed to keep you looking at the shiny object, while the machinery that actually governs your life gets quietly rearranged behind you. This is the Supreme Court's 7-2 emergency ruling on nationwide injunctions. And right here, right now, I'm going to tell you exactly what happened, exactly why it matters, and exactly who had every incentive in the world to make sure you never fully understood it. If you've been waiting for a channel that refuses to let the stories that actually reshape your life get buried under the noise, subscribe right now. Hit that button before we go any further, because what I'm about to walk you through is the kind of reporting that powerful institutions spend enormous amounts of money trying to make sure it never reaches ordinary people. You deserve to know what's happening to the country you live in. Now let's get into it. Here's the thing about nationwide injunctions that official Washington, both parties, both ends of Pennsylvania Avenue, both sides of every cable news debate has spent years carefully, deliberately, and very profitably avoiding any honest conversation about. They stopped being a legal remedy a long time ago at some point, and you can debate exactly when it happened. Nationwide injunctions stopped being a tool of justice and became something else entirely. They became a weapon, a loaded, shameless, thoroughly bipartisan weapon that both political parties picked up and used every single time. So the democratic process produced an outcome they didn't like, and the mechanism was so simple, so efficient, so surgically effective that it's almost insulting once you see it clearly. Here's how it worked. You lose in Congress, your party couldn't build the coalition, the voters didn't move your way, the legislative process, messy, slow, demanding, requiring compromise and persuasion and actual democratic work produced an outcome your side couldn't stomach, so you didn't accept it. You picked up the phone, you called your lawyers, and you asked them one single question. Which federal district court is most likely to give us what we want? That's the whole strategy. That's the entire playbook. So you find the jurisdiction, you find the sympathetic judge, you file the lawsuit, you get the injunction, and suddenly, one single unelected federal judge sitting in one city in one corner of this enormous 330 million person country has just frozen a law or an executive action or a policy for every single American based on a lawsuit brought by a handful of plaintiffs who may not represent anyone beyond their own zip code. That is not what the Constitution created. That is not how American democracy was designed to function. And what should make every honest person furious, regardless of whether they're wearing red or blue, is that everybody knew it. And every serious legal scholar who's published on this, every federal judge who's been paying attention to the institutional drift, every attorney general who filed one of these injunctions while screaming about judicial overreach when the other side did the exact same thing. They all knew the system was broken. They all knew it. They kept using it anyway, because winning felt better than fixing the problem, because the shortcut was available, because if you have access to a loaded weapon and your opponent can grab it too, the answer everyone in Washington settled on was not to put the weapon down, it was to make sure your side grabbed it first. The Supreme Court of the United States just decided that the problem can no longer be ignored. And the response it chose was not gradual, not diplomatic, and not procedural. It was an emergency order issued in the middle of the night, signed by 7 justices. That changed the rules for every federal court in America to understand why this came down as an emergency order. Not after months of oral arguments, not after a full briefing schedule, not through the normal deliberate pace of the court. You have to understand what was actually unfolding on the ground in the weeks and months before this decision landed. Because the situation had deteriorated to a point where the justices apparently made a collective judgment that waiting was no longer responsible. In the period leading up to this ruling, multiple states had gone to federal court, raising substantive constitutional challenges to what they described as a sustained, accelerating pattern of federal overreach. And these weren't fringe actors. These weren't conspiracy theorists or political provocateurs looking for attention. These were sitting governors, state attorneys general, state legislators, duly elected representatives of state governments, who stood up and said, plainly and directly, that the federal government had been operating outside its constitutional boundaries. Their argument was specific. Federal agencies had been issuing rules, directives, and mandates under the cover of emergency powers and executive authority that effectively rewrote state law without any legislative mandate, without any democratic vote, without any meaningful accountability to the people being governed by those rules. These are serious claims. They deserve serious engagement. They demand rigorous judicial examination. And here is where the story turns from frustrating to infuriating, because what the states got instead of serious engagement was the very thing they were complaining about, delivered with extra force and extra speed. Lower federal courts, the district courts and circuit courts that sit beneath the Supreme Court, responded to these state constitutional challenges by issuing nationwide injunctions against the state laws themselves. Read that again slowly because it deserves to land. States went to court arguing that the federal government was overstepping its constitutional authority, and the federal court system responded by using its own authority to block state laws sort of nationwide before those laws even fully went into effect. The federal judiciary, rather than functioning as the independent check on executive power that the framers designed it to be, was functioning as an extension of that executive power, using the blunt, sweeping instrument of the nationwide injunction to neutralize democratic state governance before it could even be meaningfully evaluated on its merits. The Supreme Court saw what was happening. The justices saw the pattern, not an isolated mistake by one overzealous district court judge, but a normalized, almost reflexive institutional habit. Lower courts issuing sweeping national blocks that bore no proportional relationship to the actual legal injuries suffered by the actual plaintiffs standing in front of them. The court had sent signals before, most directly in Labrador v. Poe, where similar limits were sketched around the scope of lower court power. Those signals weren't enough. The practice continued. And so 7 justices did what justices do only in situations of genuine constitutional emergency. They acted immediately, at night, without waiting. Now let's get to what the justices themselves actually wrote, because the language coming out of this ruling is not dry legal boilerplate. It is pointed, it is direct, and in several passages it reads like justices who have been watching something break for years and finally decided the moment had come to say plainly what they actually think. Justice Gorsuch wrote a concurring opinion, meaning he agreed with the majority's decision but wanted to put his own reasoning on the record separately, and the central phrase he used has already become one of the defining legal statements of this year. Gorsuch wrote that lower federal courts issuing sweeping nationwide injunctions are acting, in his words, like many legislators. Let that sit for a moment. A sitting justice of the United States Supreme Court looked at the behavior of federal district court judges and said they are not functioning as judges. They are functioning as lawmakers, unelected lawmakers, lawmakers accountable to no constituency, answerable to no election, subject to no democratic process of any kind, imposing national policy outcomes on the entire country based on a lawsuit brought by a small group of plaintiffs in a single jurisdiction. Gorsuch went deeper than just the diagnosis. He made the constitutional argument for what must replace this broken system, a return to what he called the traditional limits of equitable relief, the long-standing legal principle that a court's remedy must be proportional to the actual injury suffered by the actual party standing before that court. The logic is clean and it's correct. If you hurt one person, a judge can order you to stop hurting that person. The judge cannot, based on that one person's lawsuit, ban your behavior toward 330 million people who were never part of the case, who never had standing, and who may not even share the same circumstances or legal injury. That isn't justice. That is policy. And policy, Gorsuch's argument makes clear, belongs to the branches of government that are actually answerable to the people who have to live under it. Justice Sonia Sotomayor one of the two dissenters, raised a counter-argument that deserves honest engagement rather than dismissal, because she is not wrong, that there are real complications here. Her concern is practical and it's serious. If injunctive relief can only protect the specific plaintiffs who filed a particular lawsuit, you potentially end up with a fractured legal landscape where the same federal law is enforceable in 20 states and blocked in 30, where your rights under a federal ruling depend entirely on whether you happen to be a named party in that specific litigation. Unequal enforcement. Inconsistent legal realities for people living under the same federal government and theoretically protected by the same Constitution. These are legitimate concerns, and I won't pretend otherwise. But here is why the majority wasn't persuaded, and why I believe they were right to hold the line even. Understanding that the short-term turbulence is real, the system Sotomayor is defending the world of sweeping nationwide injunctions, doesn't actually solve the inequality problem. It relocates it. It creates a different, arguably worse kind of inequality, one where national policy is determined not by elections or legislation, but by which side had better lawyers, more resources, and the tactical intelligence to file in the right courthouse in the right zip code. That's not justice either. The majority made the harder choice, and they made it clearly. So where does this ruling actually reach in your life? Because this stops being an abstract legal debate. The moment you connect it to your paycheck, your family, your community, and the policies that shape what's possible in the state where you live, start with immigration. Because immigration has been the single most litigated policy arena of the past decade. And nationwide injunctions have been the weapon of choice for every administration that found itself losing in court. Under Donald Trump, travel ban policies were frozen within days of being signed by district court judges issuing nationwide injunctions before the executive orders could even be implemented. Under Joe Biden, immigration enforcement priorities were blocked from the other direction, with conservative-leaning district courts issuing their own sweeping national orders. The result was years of whiplash, legal chaos, and policy paralysis. Not because the underlying constitutional questions weren't serious, they were, but because both sides found it far more efficient to shop for sympathetic judges than to build durable legislative solutions that could survive the next election. Under the framework the Supreme Court just established, that dynamic becomes dramatically harder to execute. A state cannot have its entire immigration enforcement apparatus frozen by a court order triggered by plaintiffs with no direct connection to that state's specific circumstances. Now move to guns, because the consequences here are immediate and concrete regardless of where you stand on the underlying policy debate. Multiple states in recent years passed significant gun safety legislation, expanded background checks, red flag laws, assault weapons restrictions, and in case after case, those laws were challenged in federal court and hit with nationwide injunctions that froze them, not just in the state that passed them, but across the board. And that dynamic just changed. A state that passes a gun law now has meaningful runway to actually implement and enforce it, while legal challenges work through the proper process. On elections, which is the most politically volatile terrain this ruling touches, nationwide injunctions have been used aggressively on voter ID laws, absentee ballot regulations, redistricting challenges, early voting rules, with each side seeking broad national blocks whenever a favorable ruling seemed within reach. The Supreme Court's decision makes it dramatically harder to use a single lawsuit to freeze elections. Rules nationwide, which means election policy is going to have to be fought where it was always supposed to be fought, in state legislatures, in Congress, and at the ballot box. And for anyone who cares about environmental protection, and you should, because the consequences of regulatory failure in this area are multi-generational. This ruling hits hard in ways the environmental community is only beginning to process. The Clean Power Plan, methane emission rules, water quality regulations, endangered species protections, all of these have at various points been paralyzed by nationwide injunctions issued by district courts. If your strategy for protecting the environment has been relying on federal courts to enforce standards that Congress won't codify and state legislators won't protect, that strategy just became significantly less reliable. The fight moves to legislatures, which means the fight moves to elections, which means the fight moves to you. If you've made it this far, and you're thinking this is exactly the kind of reporting you need more of, The kind that refuses to pick a team, refuses to pretend everything is fine, and refuses to let the stories that actually matter get buried under the noise. Subscribe. Right now, this channel does accountability, not theater, not partisanship, accountability. And right now, accountability is the most valuable thing in American journalism. Now let's talk about the political fallout, because the way different institutions are responding to this ruling tells you everything you need to know about who actually benefited from the old broken system. The White House and the Department of Justice released what can only be described as carefully managed non-statements in the hours after the ruling came down. Not outrage, not celebration, not even a coherent policy position. Something along the lines of having reviewed the court's order and assessing its implications. That is the language of an institution that just took a significant institutional hit and is trying to figure out how to absorb it without admitting how badly it stings. And inside the DOJ, according to people who work there, officials were using one word privately to describe this ruling. Earthquake. Not a procedural adjustment, not a minor recalibration, an earthquake. Because what the Supreme Court just did is not a tweak that can be managed around the edges with creative legal argumentation. It is a structural shift in how a government can use the judiciary to advance its policy agenda, and the federal government's own lawyers know it better than anyone. Meanwhile, state attorneys general weren't waiting for anyone's permission to move. Within hours of the ruling, AGs from multiple states had already filed supplemental legal briefs in ongoing cases, citing this Supreme Court decision as direct authority for their arguments against federal overreach. These legal teams have been watching the court for exactly this kind of ruling, and they were ready the moment it landed. Now here is the hypocrisy that needs to be called out plainly and without partisan softening, because both sides are guilty and both sides deserve to hear it said directly. This ruling doesn't favor one party. It doesn't entrench one ideology. It changes the rules for everyone equally. And the reason that matters is that both parties spent years using nationwide injunctions as a substitute for the actual work of governance. When Democrats controlled the White House, it was Republican state attorneys general filing for nationwide injunctions to freeze progressive federal regulations. When Republicans controlled the White House, it was Democratic state attorneys general filing for the exact same nationwide injunctions to freeze conservative federal policies. And every single one of them called it constitutional principle when they were the ones filing. Every single one of them called it judicial overreach. When the other side did it, the hypocrisy was total. It was bipartisan and it was deliberate. The Supreme Court just told all of them the same thing simultaneously. You don't get to manufacture national policy outcomes by finding the right judge in the right zip code. If you want to govern this country, go win elections. If you want to make law, go pass legislation. Go do the actual work of democracy. The fury being generated in certain quarters right now tells you exactly how much certain people were depending on the shortcut this court just eliminated. So where does this actually go from here? What does the road ahead look like for American law, for American politics, for the ordinary person trying to figure out how a Supreme Court emergency ruling issued in the middle of the night translates into the daily reality of their life? The first thing to understand is that this was an emergency order, not a final comprehensive merits opinion. The underlying cases return to the lower courts, which must now apply the new, narrower framework to the actual disputes at hand, and those lower courts will be doing that work under a level of scrutiny they haven't faced in years, because every federal judge in this country now knows the Supreme Court is watching, and that a sweeping nationwide injunction issued without rigorous, specific justification is going to get reversed fast and publicly. The deterrent effect of that reality should not be underestimated. The federal government will push back. It will find test cases where it can argue the national interest is compelling enough to justify broader relief, even within the new framework. There will be circuit splits, situations where different federal appellate courts interpret the new standard in contradictory ways, and those splits will eventually force the Supreme Court back in with a full merits decision that fills in the remaining gaps. This is the beginning of a long legal recalibration, not the end of the story. But here is what will not go back to the way it was. The Supreme Court has now formally, publicly, with a 7-2 supermajority that crossed ideological lines in ways the political Media is still struggling to process, declared that using nationwide injunctions as a tool of political warfare is constitutionally illegitimate. That declaration changes how lawyers advise clients. It changes how advocacy organizations build their legal strategies from the ground up. It changes how federal agencies calculate risk when they issue new rules and directives. It changes how states think about the legal exposure they face when they pass controversial legislation. The entire strategic calculus of American legal activism just shifted, and there is no honest legal professional in this country who would tell you otherwise. There is a deeper implication here that deserves to be stated with a clarity it almost never receives in mainstream coverage. For years, honestly, for decades, both political parties have been quietly, comfortably dependent on a federal judiciary that had accumulated power it was never constitutionally designed to hold. Not because the judges were corrupt, not because the lawyers filing these cases were evil, but because it was convenient, because it worked, because it meant you could achieve national policy outcomes without doing the grinding, difficult, perpetually frustrating work of building democratic majorities. You could change the country without convincing the country. You could win without governing, and you could impose your agenda on 330 million people without asking a single one of them for permission beyond the small group of plaintiffs you recruited to stand next to you in a strategically chosen courthouse. The Supreme Court just closed that exit. 7 justices, conservative and liberal, appointed by presidents of both parties, ideologically distinct in countless ways, looked at where American democracy had drifted and decided together that it needed to be pulled back toward what the Constitution actually created, a system that is harder, a system that requires more from elected officials, a system that demands more from citizens, a system that cannot be shortcut by whoever has the cleverest legal theory and the most convenient courthouse 3-time zones away from the people being affected. That system is messier, it produces slower results, and it will frustrate people on every side of every debate at various moments. There will be periods where something you believe in deeply gets blocked in a legislature, gets killed in an election, fails to achieve the breakthrough you know it deserves, and the old shortcut won't be available to bail it out. That is real. That is a legitimate cost of what just happened. But that system is unambiguously more honest. It is more legitimate. It is more faithful to the democratic promise that every generation of Americans has been told from their first civics class to their last presidential election this country is built on. The promise that power flows from the people, that elections matter, that the work of self-governance, as exhausting and imperfect and frequently maddening as it is the actual mechanism by which a free people shape their own future. The court can draw that line. It cannot force anyone to respect it. It cannot compel politicians to stop looking for workarounds. It cannot make citizens pay attention when paying attention is hard. That part is up to the voters. That part is up to the citizens. That part is up to every American who's watching right now and deciding whether self-government is actually worth the effort it honestly, genuinely requires. The Supreme Court's 7-2 emergency ruling on nationwide injunctions is a turning point. Not because it solves every problem, not because it ends every fight, not because the road from here is simple or short, but because it forces a country that has spent decades outsourcing its hardest, most uncomfortable political questions to courtrooms to finally confront those questions where they were always supposed to be confronted, in legislatures, in elections, in the direct, demanding, irreplaceable democratic engagement of a self-governing people who have to be willing to show up, speak up, and do the work. That is the full weight of what just happened. That is the story they hoped would disappear before you got to it. You didn't let it disappear. Now share it with someone who needs to hear it. Tell me in the comments which policy area, immigration, guns, elections, the environment you think gets transformed most dramatically by this ruling and why. And if you believe that real journalism means telling people what actually matters, even when it is deeply inconvenient for every institution and every political actor currently in power, then subscribe right now, because the stories that genuinely change your life are exactly the ones that get buried the fastest. And this channel is not in the business of letting them disappear.